Thank you very much for investing your time in this video. I hope you find the information useful, as I try and do every week. A lot of the material that I use is based on everyday situations that crop up, questions that are asked or offers that I see, so on. And this really comes down to an agreement of purchase and sale that I saw last week and some concerns I have about it. Now, why am I raising it? Because the way it was structured, I don't think the salesperson created the clauses that I have problem with. I think they originated with the brokerage. And I'm not trying to take a shot at a brokerage. I'm not going to tell you what brokerage it is. But if it did originate at the brokerage, it's going to appear again. It's going to be a templated thing that the agents use. You need to be aware of it. There are some certain things in it that you might miss that you absolutely need to know about. But before I get into that, I need to review with you a document called a Seller Property Information Statement and also a Residential Information Checklist, because it's referenced here and we're going to come back to it. We need to know what it is. Some years ago, it was the norm to use seller property information statements, and it was a very exhaustive questionnaire that you went over with your seller, and it gave you the scope and background history of the property and any deficiencies, any problems whether they're latent or whether they're patent defects. They would become highlighted. The history, the problem. Have you ever had water leakage? Have you ever had a sewer backup? Have you ever had this? Have a very, very extensive questionnaire. I always like them because I feel that when you're buying a property, if you're the buyer, you've got a right to know what you're buying. And so there's no surprises later, and there's a fair price for what you're buying rather than smoke and mirrors and hidden things and so on. So I like the seller property information statement, but lawyers hated them. Well, I should qualify that. If the lawyer represented the seller, they hated them. If they represented the buyer, they liked them. And the reason why they hated it when a seller was using it was because it highlighted patent defects. And of course, that's caveat emptor, buyer beware. It's up to the buyer to find those, not up to the seller to tell them. And so they didn't like them to use it. So AREA came up with the Residential Information Checklist, which was an SPIS, but not to be made public. They said there's really good reason for a realtor to use this, and I believe there is. So use the Residential Information Checklist, go over it with your seller point by point, and you'll find out the scope of the property, and there may be latent defects that you've got an obligation to disclose, and the seller forgets to tell you, and this questionnaire will bring it to light. So use the Residential Information Checklist. Don't reference on the listing that it's there, stick it in the file, but if it brings to light any latent defects, then you need to notify buyers about them. Okay, so there's in the offer, back to the offer that I've got a problem with. 4 specific things in the offer that I want to bring your attention to. Let me highlight them for you. The first is the buyer has been made aware of the benefits of having a due diligence condition, not limited to a home inspection or financing condition, but have declined the same. It's the first one. The second one, the seller represents and warrants. That representation and warranty, and then there was an extensive list of what they represented and warranted, and then of course it went on and said, the parties agree that this representation and warranty shall survive and not merge on completion of the transaction, but apply only to the state of the property at the completion of the transaction. Then the third thing is this statement. During the time the seller owned the property, no improvements have been done without a required permit. And then finally there was this. There are no yes answers to any questions on the seller property information statement or the residential information checklist. It doesn't say there is one, it says there are no yes answers on one. Okay, so why do I have a problem? Well, the first one is this issue where the buyer states he made aware of his opportunity to get a building inspection and whatever, and he's waived that right and he's declined the opportunity. The question, if a problem arises, is who's liable? And the courts take the position, generally, that if a buyer has seen the property himself, and then he's gone on and he's hired a building inspector to inspect the property, the obligation is off the shoulders of the seller unless it's a latent defect. It's up to the buyer to find out these problems. So what happens here is if it goes to court, you should always ask yourself with any question that comes up on a contract, what would happen if it went to court? So if it goes to court, the buyer would say, Your Honor, I chose not to have a building inspection, realized I could have, because I relied on the integrity and honesty of the seller, and he misled me. So what we're doing is we're dumping the obligation on your seller. Not to want the seller to lie or mislead or anything, but we're saying that and by putting in the offer that I know I could have got an inspection, but I declined it, is totally ammunition for court. That's why it's there. The second thing, the warranties. The warranties, and as I read through this offer, they warranted everything. They didn't just say that the pool's in good working order. They said we warrant the pool pump, the water lines, the vacuum cleaner, the chlorinator, the filter system, the liner, the solar blanket, on and on and on. And it went on from there. There's never been any water damage in the property. There's never been any sewer issues, never been any insurance claims, and a huge long list of all the things that the seller would warrant. So that was all tied in. Now, it wasn't just latent defects, it was patent defects. So they're moving it out of buyer beware and putting it under the seller misled me. All right. The third thing is this thing about permits. And I want you to understand, a lot of us think that a permit is required if we've changed the footprint of the property. We've added a sunroom, we've added a garage, some of the things that we see that weren't there when the owner took possession originally, and did he get a building permit? And that makes sense. I understand that. But if you talk to City Hall, they will tell you if you put a closet in a rec room, you need a building permit. If you put a bar in your rec room, you need a building permit. If you put a deck in the back, you need a building permit. And if you go through what they require a building permit for, you'll find out almost every house in the city of St. Catharines, if it's been owned any length of time, has had some kind of improvements without building permits. And the seller's saying, didn't happen. Careful with that one. But then number four. Number four says the seller property information checklist, if we had one, would have no yes answers. Well, first of all, that's inappropriate. Number 7 under general says, is there a plan of survey? So if we say yes, we're contradicting what we say here under the general SPIS. Is the property connected to municipal water? We say yes, got a problem. Is it connected to sewer? We say yes, it's got a problem. Does a fuel oil tank comply with technical standards? If we say yes, we've got a problem. And so there's a number of the ones you want to say yes. And the other thing, though, is that we're basically bringing in a seller property information statement when the seller has elected to not have one. And we're even encompassing a residential information checklist, which is designed to not be made public. And we're trying to cover all this and corner the seller into a warranty that's ironclad that the buyer can go back on the seller. And if you're representing the seller, do you really want to put your seller in that position? So I would suggest you see this, cross the whole thing out. Now, there are times when you need warranties. I think we're out of control in this warranty business. I think if you're buying a property that's got a pool and you're closing in January, you want a warranty because you can't check the pool to make sure the things are working. So you warrant that the seller says at the time of closing and the time of the closing of the transaction, the time of the opening of the pool is in good working order and that'll survive and not merge and closing. Fair enough. But why say a bunch of things that you can check? Why say furnace is in good working order? Get a building inspector and find out. Find out these things yourself. So cross it out, the ones that don't apply, and then say the buyer shall have 5 days to do his due diligence or to bring in a certified building inspector to do a proper building inspection and receive a report satisfactory to him. Put that in instead. Throw the onus back on the purchaser. Now, I understand that the argument could be, well, this is an unconditional offer. It's unconditional because we put it all on the shoulders of the seller. And if the seller is adamant about wanting to accept it and he doesn't want to sign it back, but make sure your seller understands the liability he's inheriting when he gets an offer that's set up that way. And so I hope that makes sense. If you see it, try and remember the video or go back and watch it and go check through the offer and you'll see what I'm talking about. I want to thank you very much for investing your time in the video. I look forward to talking to you again next week.